In my 2019 speech, I condemned the totally baseless, arbitrary, and even malicious attacks on some of our judges, urging the community to dispel such unwarranted misunderstanding by reading the court judgments. Last year, I have witnessed multiple occasions by which similar reminders have had to be made. Our judicial independence is premised on solid infrastructure that has been laid down primarily in the Basic Law, the security of tenure, the immunity of judges, the non-revolving door, and importantly, the expressed provision in Article 85 of the Basic Law that guarantees judicial independence free from any interference. The judicial oath taken by all judges requires them to safeguard the law and administer justice without fear or favor. Judges are required to adjudicate cases independently and impartially. Comments and discussions on court decisions are always permissible within the boundary of the law if done rationally and objectively. Yet, some remarks that have surfaced are nothing like that. Any unfair or unfounded remarks with the ulterior motive of exerting pressure or undue influence on our judges in dispensing justice will be to no avail. Another baseless challenge to our rule of law relates to the promulgation of the national security law in Hong Kong. National security is within the purview of the central authorities. The National People's Congress is the highest organ of the state power in the People's Republic of China, and its standing committee was entrusted to formulate the national security law. Pursuant to Article 18 of the Basic Law, it was added to Annex 3, promulgated, and became applicable to the Hong Kong SAR. Article 23 of the Basic Law does not change the fundamental principles set out above. It imposes a constitutional responsibility on the Hong Kong SAR to enact legislation in respect of certain offences relating to national security. Yet, the central authorities always have the power and duty to legislate on matters of national security, especially when this responsibility of the Hong Kong SAR has not been fulfilled. It is entirely misconceived to say that the principle of one country, two systems have been undermined. Many unfair and ill-informed criticisms have been made against the designation of judges by the Chief Executive, with remarks that it will undermine Hong Kong's judicial system. It should be reiterated that the Chief Executive only designates a list of judges in different levels of courts to hear cases involving issues of national security, rather than assigning which judge to preside over a specific case.